So first of all, let me thank every one of you for joining, and also to the speakers, of course, for participating, and especially to Amanda Lee and Imad Khan for organizing this program. I want to just take one moment to talk about ICDR Young and International. So, we are the Young Practitioners Group of the ICDR, and we're putting together programs and initiatives for networking and to promote arbitration in general. You can go and see all of our initiatives in our website, ICDR Young and International, or you type ICDR Y&I, you should also be able to find us. You'll see there the upcoming programs, as well as previous webinars that we have recorded and uploaded there. And you'll also be able to join our distribution list as a Y&I associate. There's a form there that you can complete and send to us. But if you're even too busy to complete a form, which we understand we're all busy these days, you can just go to LinkedIn and find our LinkedIn group, ICDR Young and International. And if you request to join, we'll accept you. And you'll be able to keep also updated of our upcoming initiatives there. We will make sure to post anything new that we have. So with that, I don't want to take any more time because I know we have a lot to cover. So I will leave the floor to our moderators, Amanda Lee and Imad Khan. Imad, Amanda, the floor is yours. Thank you very much.
Thank you so much, Rafa. Hi, everyone. Thank you so much for joining us today. My name is Imad Khan. I'm a senior associate with Winston Strawn's Disputes Group, and I have the pleasure of serving on the executive board of the ICDR Y&I. So I will certainly shout out to Rafa's message of please join the ICDR Y&I for programming like this, as well as others to promote young practitioners and students in the field of international dispute resolution. The topic today that we will discuss has to do with diversity in the current time period. The reason we chose to discuss this topic really has to do with the fact that, a few months ago, of course, all of us were struck very surprisingly by COVID-19, which resulted in the shutdown of many cities. It also raised a number of issues in the media regarding the effects of COVID-19, among other things, to diversity and inclusion efforts that have been rather important in the legal profession over the last decade. A lot of press articles and a discussion on chat boards regarding, well, are we heading back towards what happened in 2008 during the recession and the bad or impact that that had on diversity and inclusion issues. So a few months ago, that's the conversation that Amanda and I were having about the kind of programming that we would like to put forward in order to not only address that there was a risk that, any gains made in the D&I space might go backwards. Of course, in the meantime, as many of you will know, we have had other movements take place across the globe. The BLM movement in the US, which has spread across the world, which has further spotlighted issues regarding racial diversity as well as representation when it comes to international dispute resolution, but also beyond international dispute resolution, the legal profession as a whole. So what we wanted to do today, our aim today, which will be really taken not so much by me, but by our moderator, Amanda Lee, as well as our speaker, who I'll introduce very shortly. The goal will be to address the challenges we might face, but not just address what the challenges are, but also come up with concrete tasks or concrete steps that we can take to level the playing field in order to address these challenges. We didn't want to have just another discussion on identifying the issues, but we want to take it a step further and talk about what we can do as this group of speakers, as well as the attendees who are here, in order to engage with D&I, lean into D&I even more so that we can really ensure that we are leveling the playing field rather than just talking about it or identifying the issues that there are. So with that, I will introduce our esteemed moderator, Amanda Lee, who has the very important task of leading this discussion today with a great group of speakers. Amanda is a solicitor with Seymour's. I'm pleased to say that she's also a member of the Global Advisory Board of the ICDR Y&I, so we get to work together on programs such as these, among others. Amanda is also a director of Arbitral Women, which is also one of our hosts and sponsors today. And Amanda serves as an ambassador for Alliance for Equality in Dispute Resolution. Unsurprisingly, when we were discussing this program, Amanda was a clear choice for me to at least work with because I know her commitment to diversity and inclusion in the legal profession as well as in the international dispute resolution space. The speakers today have a similar track record of being rather invested in diversity and inclusion as well as representation across the legal profession. So first, I'll introduce our speaker, Michelle Curtis von der Haar, who is a Deputy General Counsel and Assistant Secretary of Hewlett-Packard. She leads the global legal affairs team there. She's based in San Francisco, which I believe is rather apparent now with her amazing backdrop, which is slightly envious, especially as a Californian. And Michelle has been also involved in corporate diversity initiatives at HP and also previously in her other positions. Our next speaker is Paula Hinton, who is a partner with Winston Strawn in its Houston office. And I, of course, have the pleasure of calling her one of my mentors and sponsors. So you can see her diversity efforts sitting right in front of you right now. She serves on the firm's executive committee, and she has chaired the award-winning Women's Leadership Initiative with Winston and Strawn. She's also a member of the firm's Diversity and Inclusion Committee and has served in a number of different roles, focusing on advancement of women in the legal profession. Our next speaker is Ann Lesser, who is a Vice President of Labor, Employment, and Elections Division of the American Arbitrators Association in New York, whose international arm, of course, is the ICDR. She oversees the labor caseload for the AAA, user outreach, election services, and panel of labor and employment neutrals in New York and New England. And she is also one of the task force members for diversity initiatives undertaken by the AAA. Our next speaker is Michael Nickelrath, who is the global leader for Baker Hughes, based in Florence, Italy. In 2017, Michael was recognized by Arbitral Women as a champion of change for his work in promoting diversity in arbitration. He's one of the first in-house counsel to receive such a recognition. In addition to his role at Baker Hughes, Michael is also the chair of the governing body of dispute resolution for the ICC. And last but not least is another friend, Leslie Richards-Yellen, who is the Director of Inclusion for the Americas at Hogan Lovells, based in New York, where she plays a key role in directing the evolution of the firm's diversity and inclusion efforts. Her many diversity-related appointments include serving as advisory board member of the Institute for Inclusion in the Legal Profession and acting as co-chair of the Diversity and International Committee for Women in Law Empowerment Forum. So with that, I will hand it over to Amanda Lee to take our discussion.
Thank you very much, Imad. Good evening, good afternoon, good morning to everybody around the world. I'm beginning to feel a little bit as if I'm on the Truman Show nowadays because I have to go through so many different time zones for webinar introductions. Thank you for the kind introduction. I'm delighted to be welcoming such fantastic speakers to share their views with everybody today. And today's topic, One Step Forward, Two Steps Back, mitigating the impact of COVID-19 on diversity and recognizing opportunities to level the playing field, is a broad and important one. We're going to try and add some value to this important discussion, as Imad has said, by to move things forward. Steps that institutions, laws, corporate individuals can take to pull down or improve their prospects of success during these challenging marketing conditions. If you have any questions for our please feel free to share them at the bottom. I'm having some problems, hopefully. Okay. If you have any questions, please share them in the chat box as we go along, and we will do our best to ask our esteemed panel. So we're going to start today by exploring the approach that's been taken by law firms to diversity initiatives. So let's start with a question for Paula and Leslie. What steps have your firms taken internationally to protect diversity gains during COVID-19?
Well, I'll start and then pass to Leslie. Leslie and I have been very simpatico in this arena for a number of years. I think today, and I want to talk about the situation today and what the firms are putting in place, is more so now than ever is directed at real programs. I think one of the things many of the firms are doing, and Leslie can put more legs on this, is the task forces to come up with real proposed solutions to not only open the pipeline for more diverse attorneys into the firms by going beyond what they've done in the past, but also programs such as getting rid of the free market system for young diverse attorneys and all young attorneys in the workflow, to be sure that we're monitoring the work assignments and that everyone is getting an opportunity in a level playing field. One of the other things we've done is in our sponsorship programs for diverse and women attorneys, rather than merely appoint a partner in the firm they might work with, we actually use our executive committee to be those sponsors. We decided that it was important for our women and diverse attorneys to have partners who are in positions of power, who need to get to know them and facilitate their career. So those are just a couple of examples of what we're doing to try to help the pipeline and then the advancement.
Thanks. Thanks, Paula. What's really interesting about COVID-19 is that it works on the forces that hurt diverse people. So for example, once people are not in the workplace, you need to really watch to make sure that work is distributed in a fair way, that people don't just go to their go-to people. It's harder now to do work, although over time it's gotten a lot better, but it still is harder to do work now than it was when you were in an office. So we started just pretty much instantly sending out emails to partners and asking them to look at who they are assigning work to measure, to figure out whether they could send work to people that they didn't ordinarily send work to. We focus a lot on feedback because sometimes it's hard enough to get feedback when you're sitting next door to each other, but certainly it's harder to get feedback when you're sitting in your living room or your kitchen in your home. So we tried to put a lot of the obligation on partners to staff, knowing that their bias might naturally spring into place to provide meaningful feedback. So that was one step that we undertook. Another step was, how do you build community? There are a lot of young associates in our system that are in one-bedroom apartments in a city that maybe they're not that familiar with, maybe they just moved there. So how could we magnify a sense of community and belonging? So we spent a lot of time with our affinity groups. We have, in the Americas, we have 30 different slices of affinity groups. And so we had sometimes calls every week, every 2 weeks with different subsets of groups. So we provided ways that they could do virtual, now it's ubiquitous, but the cocktail parties, the prompts, the icebreakers, ways that they could get together and just continue to be a family and be a place where people could hopefully trust the leaders of the affinity groups to raise questions. We also focus on mental health because this is an isolating time. It's a time when families are taking care of children and trying to do work, or you're trying to take care of your loved ones. I for one, my dad's in Sioux Falls, South Dakota, and I can't go see him. And it makes your life so much harder. And so we are very lucky that we have in our big offices therapists on site. So we directed people to therapists and tried to lovingly watch out for each other in that way. So that's part of what we did. And one final thing is, I'm a big process queen. I believe You know, we can work on ourselves and try to be better people and not be biased, but process is really the proof of the pudding. So we tried from a US perspective to look at the hours of cohorts of diverse and women and LGBT plus attorneys to look at their hours. And if we saw things that were awry, to follow up with that. So those are some of the things that we tried to do.
Thank you very much. We've touched a little bit on some aspects of my next question. Let's give you both the opportunity to share anything else that you wish to share. How can law firms build more diverse teams and ensure that after they've built those teams, they give each member of the team opportunities to develop and thrive? So not just during times of crisis, but when things are good as well.
I'm seeing, and Paula, you're probably seeing the same thing. I am seeing corporations really step up in a way that I have never in my life seen during COVID. I can't tell you how many letters we got from our clients saying, we will be checking your diversity numbers after this is over. We want you to invest in diversity. So there's client pressure, which I welcome. But what I love now is I'm seeing clients thinking that they can also help us in diversity efforts and they can invest in our people with us. You know, so I'm seeing clients not only requesting diverse teams, but following up with data about who's working on those teams and their hours. And then clients saying, you know what, can we be part of your feedback system? And can we give feedback to young lawyers who work with us a lot? Or we want to adopt certain cohort of people and we want to invest in them. So we're seeing a lot of that. Are you seeing that at Winston, Paula?
I am, and in fact, there are clients. I had noted this question, and one of the things with this group here today I wanted to do was say, please, clients, put pressure on the law firms, mandate it. Don't give lip service to it, as has happened for many years, people saying they were going to do it, and very few being punitive about it, but say you're going to do it, mandate it, and enforce it. I've got clients today, for the first time in a decade, are requesting our diversity statistics for their teams and mandating the measurements and the input. And that is fabulous. But the main thing is the way we're going to change is if the clients mandate it and the firms mandate it, we will see real change. And those are two things that have to happen to create these diverse teams and opportunities.
Thank you both very much. Is there anything else we can do? Is there anything else that law firms are not doing so far, do you think?
Probably many, many things. And that's why every time we have a conversation, I say, we are not reinventing the wheel. Somebody out there has thought of something. And I welcome anybody in this group. Please email me on a program idea, an opportunity idea. Leslie and I know we aren't the first people to be passionate about this, but we know many of you have better ideas than we may have at the present time. So we need to be sharing our tools.
I think this is a time for best practices. You see it throughout the world. I mean, you see the Mansfield Rule, and now the Mansfield Rule is going from the US to the UK. Women in Law Empowerment Forum, which is a US gold standard for senior women, that's going to the UK. I think what people are seeing is that we all want to do better, but the junk in our head is there in our brains, and it kind of subverts the way we think about who we're giving opportunities to and who we're not, and who we're giving good feedback to and who we're not. And so because we can't properly evaluate ourselves and what we do and how that affects people's trajectories, the only thing we can do is adopt best practices, I think, and measure what we're doing and the impact. And then once you understand the impact and that's a fact, then you have to look at your process and try to figure out how did we get to this point, and how can we make our process, how can we tailor it in a way to have different results. So Paula, I think that's what your firm has done and we've tried to do. I want firms not to be afraid to experiment and to maybe sometimes fail, but then learn from what they've done and try something else and collaborate and use these best practices that are out there to be better.
Thank you very much. Right, let's turn now then to the expectations of arbitration users in respect of diversity. What are organizations, what are corporations doing internationally to promote diversity, both internally and for organizations that have panel firms within your panel firms? This is a question for Michelle and Mike. I don't know if you'd like to start, Michelle.
Yeah, so going back to what Paula and Leslie have said, I really appreciate the fact that they're looking to their users of legal services to provide those opportunities to really create more diversity. At HP, well, this is domestic so far. About 3 years ago, we instituted what we call the Law Firm Initiative, which requires that our law firms at least that we have at least one relationship partner that is a woman or somebody of a traditionally underrepresented minority, and that we have at least 10% of the billable hours being performed by diverse associates. And we require that our law firms track that. Now, if the firms do not meet those diversity requirements, then we hold back 10% of the fees. Now, we don't want to hold back 10% of those fees. We want to promote diversity. And we instituted this program 3 years ago with our law firm providers, and only 47% of them met the diversity requirements 3 years ago. We track on a quarterly basis. It was, I would say, a big imposition in terms of tracking. But with our partnerships, I think firms that we partner with were very enthusiastic about seeing the progress quarter by quarter. And in the last reporting period, we had 95% achievement by our law firm providers in accordance with our diversity initiatives. So it's very exciting that we have seen progress in that regard. Now, we have only been doing this in the United States because who we designate as underrepresented would be people, women and people from underrepresented minorities, LGBTQ, and people with disabilities. Now, we can't always track that from an international perspective, but our next phase in this project is going to be looking at this more internationally on a gender basis. The next thing that we've done is recently we have partnered with an organization called Diversity Lab, along with, I would say, maybe 30 general counsels in the technology community, and 5 bold law firms who donated $1 million each to the diversity efforts to come up with bold ideas to try, and as Leslie said, to try in a very agile way, like failing is okay and learning fast is okay. And so they have initiated a Mansfield certification that they will track. I know a number of law firms have signed up to that, and HP has also recently signed up to the Mansfield certification, which requires that when we hire, at least 50% of the slate is of underrepresented minorities, and those would be for positions both incoming into HP legal as well as promotional opportunities within the legal department. So if we're looking for internal candidates only, that we will make sure that at least 50% of the slate is diverse candidates. And in addition, that will also require that when we change our law firms, that we impose the same expectations of our law firms. So we're pretty excited about that. It is, I would say, hard. This requires an enormous amount of effort from our company and our legal services providers. It's not the easy solution. It requires that when we decide to use counsel, that we really are intentional about looking at things through a diversity lens. And I would say in respect of COVID-19, there was one thing that I'm particularly proud of. We have a diversity and inclusion committee within the legal department, of which I'm the executive sponsor. And when COVID-19 hit, we had planned for the first time since we separated from the broader Hewlett-Packard a couple years ago, that we would have legal interns in this summer period, and we hadn't had them in a while. And we partnered with a couple of law firms, and we selected deliberately diverse candidates who would participate in the program. Now, when COVID hit, there was a lot of concern about whether we could have a meaningful program as a result of COVID, because those interns would be participating via Zoom like we all are. And we did plow forward. It was much harder to put a program together that we thought would be meaningful for them. But I was really pleased with the fact that we did it. And so I think really the key here for organizations is to really, number one, we do have a level of influence with our law firm providers. And if diversity is really important, we need to be very intentional about requiring diversity of our providers. And second, just to make sure that we are deliberate and intentional about driving diversity forward, and that means that we have to look at everything we do through a diversity lens until it becomes innate, until it becomes a habit, and that will take some time.
Thank you very much. Mike?
I agree.
Excellent.
Everything Michelle said, I agree. Very easy answer there. Actually, I'll pick on Michelle, sort of indirectly, because I make a correction of that, but no, but let's say is that you introduced me saying that I was the first in-house counsel to receive the Arbitral Women Diversity, I said, I'm the only in-house counsel to receive the Arbitral
That's also
Champion
true.
of Change Award, which I'm very proud of. And so there you go, Michelle. Well, what's Hewlett-Packard going to say to that?
Can't measure up. We can't.
Not that this should be a competition, but maybe it should be a competition. All the things we could compete on, that would be a fun one.
Lawyers are not competitive at all.
But this would be a good one to see who gets, who can do a better job. Not a bad thing to look to. Well, first of all, I would say, before we get to panel firms, it's an easy answer for me because we don't have panel. We're starting a panel firm process right now. It will be completed by the end of the year. We're relatively new in a sense of an organization. We actually have a new general counsel who's just come in. We were spun off by General Electric. GE sold its majority stake in Baker Hughes in October of last year. It continues to be an important minority shareholder, but we're really kind of cutting our own path right now. And so I feel, I can speak to what Baker Hughes, I think we're a leading oil field services and technology company. We're an energy technology company. The organization that we are is one we've been born really as one that embraces fundamental concepts of diversity. We have a diversity leader. She coordinates a number of initiatives that are based on 3 pillars. The first of those pillars is just really that we have an inclusive workplace, which is an obvious importance. And that includes the entire vision for diversity for us globally as an organization. The second pillar is people retention and development, which also includes hiring. Obviously, right now, the oil and gas industry is not doing a lot of hiring. We're doing a lot of laying off. And so where you can impact things like diversity is really on the retention side to make sure that as you're looking at, as you're downsizing, as you may in some areas, that you do that, of course, in a very equitable way, and you don't lose, you don't lose gains, you don't lose talent that you've tried very hard to bring in, and that the third pillar is external partnerships, which includes vendors, which include in that case law firms, but has also a number of other external providers that the company works with in a range of areas. There are Catalyst, Petro is another, it's active in the oil and gas field. Here in Italy, there's actually an organization that the LGBTQ community works with a lot that is called Parks. And it's named after Rosa Parks. It actually takes its name from the famous American civil rights champion. So that's the company and where we're trying to go. In terms of how we work with outside counsel, as I said, we don't have a panel. We do have outside counsel guidelines. The outside counsel guidelines, which we came out with this year, are pretty, I'd say, good with respect to requiring that we have diversity within the ranks at senior positions. It also requires that we in-house, that we in the litigation department, but when the law firms make proposals with respect to arbitrators and mediators, that they propose diverse slates. And that's something that I would say that we also do when we are working with institutions to look at selections of candidates for arbitration and mediation. And I see Tom Ventrone is one of the people here. So Tom Ventrone will back me up. Tom Ventrone with the ICDR will know that we actually use this trick with the ICDR. And I call it a trick, but it's actually a trick that allows you to use diversity to get more options. Is if you don't get from the ICDR what you consider to be an adequately diverse slate, you can go back to the ICDR in the nomination process and say, we don't think that this slate was sufficiently diverse. Give us more names. And so you actually, for the same money that you pay to the ICDR, assuming that you pay, you get double the options that you can look at. So it's actually a great way to I'd say, use diversity to leverage actually your own company interests. And then one other thing that we do, although we don't have panel firms right now, we will eventually, and I can only expect this will be part of the discussion that we will have. We do send RFPs out occasionally when we have big cases for litigation, to the extent that we outsource them, or any major matters, and we include a requirements of diversity. Unlike Hewlett-Packard, we don't really, it's not something that we measure in the RFP process. What I would say is that when you look at their responses, you can kind of see who read your RFP, right, in terms of the candidates and the teams that they're proposing. And if you've said that that's one of your values, and what comes back is, well, we just didn't look at that part, they're probably failing in other areas too, right? So it just doesn't look very good in terms of making a pitch to us. So, but I also think so a lot of this discussion that we have though is I think very North America focused. That's not my main area of responsibility. My position is global. And as we look at what is diverse around the world, we come into, I think, much more complex definitional questions once we get beyond, say, just notions of gender, which have their own complexities, which should not be considered as necessarily a binary situation, but I'd say it is not as complex as to, I've seen, for example, initiatives that look at how do we promote, for example, or provide equal opportunities to underrepresented minorities, or as you say, people of color, but you look at sub-Saharan Africa and you'd say, well, what would that be if I'm working within that area? And so I think you need to be, I don't think that we've gotten to the point yet where we have a universal concept or understanding of exactly what it is we should be doing when we look around the world, particularly when it comes to appointing arbitrators and mediators. And Amanda, I think that's something you see, because I'd say, for example, that the UK is disproportionately represented in international arbitrator appointments, for example. And so if you looked at who are the parties and the populations that find themselves in disputes, one question you could ask is how representative are the candidates, rather than look at how diverse, which is a loaded term in many areas. You could say how representative of the world of dispute resolution are the people who are getting the appointments that you look to.
Thank you very much. I think representation is a key part of this discussion, and something that we do need to spend a bit more time focusing on overall. Michelle, do you have anything that you want to add?
Like Mike, I would say I absolutely agree.
Easy moderation this panel. Everybody
yeah, very, very agreeable. No, I think, any effort you can make on the lines of diversity, and when you move more internationally, as I said, it has been a little bit more complex for us, and we're pushing forward on our sort of law firm initiative as we go international, and there will be complexities, and I do appreciate the notion of representativeness in the makeup of your outside law firm providers, but I think anything that you can do when you drive diversity forward in a very intentional and deliberate way, and again, as I said earlier, keeping a lens on really giving opportunities for diverse candidates to, reach different positions within your organization. I think that is really key. When you stop trying is when I think you're losing sight of the objective that you're trying to achieve. So it really does require an enormous amount of effort. But I think when you see those strides forward, especially that things that you're measuring, it's hugely gratifying. And so just one step at a time.
I think that's something with which we can all agree. Let's turn now to think about institutions. Diversity is arguably the responsibility of everyone, but the focus is often placed on institutions and the key role that they often play in the appointment or the suggestion of neutrals. So we're going to talk a little bit now about what institutions have been doing to promote diversity and what more can perhaps be done. So Anne, what initiatives have AAA and ICDR put in place to promote diversity and to build diverse panels of neutrals?
Thanks, Amanda. So AAA has really been committed to the growth of diversity and inclusion. It goes back really to the 70s, where we co-sponsored the first National Women's Arbitrator Development Program, which established a method for recruiting and training qualified women arbitrators. Additionally, the first diversity programs to increase women and minority arbitrators were in the labor arbitration area. And this included large unions and companies and other co-sponsors along with the AAA at that time. More recently, our diversity efforts have centered on recruiting women and minority panelists of arbitrators and mediators to serve on cases, on our educational programs, and to represent AAA in publications. I'm a co-chair of our Diversity and Inclusion Committee, and so, we assist with those initiatives, promoting events, collaborating with firms and organizations to increase the awareness and the benefits of a diversity and inclusion in arbitration and having diverse panelists on our panel. Increasing panel diversity really is part of AAA's corporate and executive goals, and has been for a number of years, and as well as divisional goals for each division, including ICDR in the organization. And executives across every region, every division and every region in the country of the organization actively recruit women and minority candidates who meet the criteria established for AAA and ICDR panels. So to give you just an idea of our initiatives and results, in 2019, 38% of our new panel members were diverse, consisting of women and or minorities. Our active panel currently consists of 26% women and minorities, and this number has actually been growing steadily over the past few years. So every year we see the number increasing by a certain percentage. It's a slow process. I wish that those numbers were higher, and I wish that it could move faster, but it is moving in an upward trend, which I think is very positive. One of the things that AAA does, it employs an algorithm in its case management system that ensures that every list that goes out to parties is 20% diverse in caseloads where this is possible. I say where it's possible because sometimes there could be a specific type of case where the expertise is so narrow that it's very difficult just to find perhaps those people who have that level of expertise. And in that situation, we have to look for those people, and it may not be possible necessarily to incorporate the 20%, but we definitely try to do that. We are 90% of the lists of the proposed arbitrators are at least 20% diverse. That works together with the tool. And in 2019, we actually surpassed our goal of 90%. And so 93% of our arbitrator lists were at least 20% diverse, and 29% of arbitrator appointments were diverse. That is up also from prior years. It was 27% in 2018 on the appointments and 90% on the list. So of course, the appointments, I think, is a very important statistic, because we can send out lists, but what really is important, and I think is the flip side of everything that institutions can try to do to increase panel diversity, is that we need to make sure that corporations and law firms are picking diverse arbitrators. Of course, that is not something we necessarily have direct control over, but it's something we like to talk about and try to encourage when we're presenting or doing programs. We also at AAA focus on the inclusion of diverse ADR professionals as speakers in our programs, and 57% of speakers in our programs in 2019 were diverse. There's a number of conferences which we do. We have a national labor conference in 2019. We had a construction conference, a life science program. Of course, across the board, you know, whether it's in the legal field, as we're all talking today, the ADR field or any other field, there's more work to be done on the issue of diversity and inclusion. But so we continue to enhance our outreach efforts, and to this end, you know, in 2019, we tried to continue to build our coalitions with national minority and local bar associations and law schools around the country. We sponsored and participated in events to provide training and create opportunities for diverse practitioners. We worked with NAMWOLF, where we actually we sponsor their conference, but we also attend and we speak a lot to many attorneys and encourage people to join our panels if they have the qualifications. And we then reach out to them, and we have a sort of expedited recruiting effort that we work together with NAMWOLF. We also sponsored the Construction Institute Women Who Build Summit, the National Bar Association Annual Conference. We provided a full day of training. We sponsored the ABA Commission on Women in the Profession Margaret Brent Awards Luncheon. We sponsored NAPABA, the National Asian Pacific American Bar Association Conference, the Minority Corporate Counsel Association Conference. We also participated in the ABA Mediation Week's theme of the importance of selecting diverse neutrals, and we held receptions in different offices around the country and talked about our diversity efforts and the importance of selecting diverse neutrals. I spoke actually in an ABA Diversity Committee Forum back in last October, and we also helped co-sponsor the Arbitral Women Implicit Bias Toolbox training. So in all of these events, AAA was, you know, involved in either co-sponsoring, organizing, hosting, providing speakers, recruitment, etc., as I've described. We're particularly proud, I think, of two programs, and I think many people may be familiar, of course, with our Higginbotham program, which is approximately about 10 years old. It was started in 2009. We launched the Higginbotham Fellows Program, which is named for Leon Higginbotham Jr., the first African-American district court judge for the Eastern District of Pennsylvania and the 7th African-American appointed as an Article III judge. And this program provides training, mentoring, and network opportunities to up-and-coming diverse ADR professionals who've historically not been included in meaningful participation in the field of ADR. The program's held every other year. It actually begins with a week-long intensive training at AAA's offices, where the fellows are taught by established mediators and arbitrators, and they engage with AAA leaders on the board, the council, the roster, and staff. So far, we've had 134 fellows who've graduated from the program, and almost all the fellows who have applied have actually advanced to AAA roster, appointments. And additionally, actually, some of the fellows are on some of AAA's council committees, including this committee. which is our diversity committee. My co-chair is actually a former Higginbotham fellow and works at AAA. Another event that we did last year, and I think this is really important, and I think even more so perhaps now in our post-COVID world, is we launched our inaugural 1.5-day Diversity Student ADR Summit. And it was a ADR Summit for diverse law students to really provide an in-depth understanding of what it means to become an arbitrator or mediator. Because, you know, the idea behind it was to take that step back further than the Higginbotham Fellows, who are already sort of young professionals in their fields, but to talk to students who are at the point of entering their careers and to really give them a realistic view of what it takes to become an arbitrator or mediator and what that entails. And the idea was that if they, you know, to give them this realistic picture so that if this is their end game, they really know how to orient their career in the right direction. And we were fine if at the end of that weekend they said, wow, maybe this isn't really for me. The idea was really to provide that realistic review and to have them know the path that they really need to take. We actually got 138 applications from around the country and overseas. We accepted 20 students from across the nation and one from Australia, and students received $1,300 stipend to cover their travel expenses. So this was something that we wanted to make available to them. The program did take place in New York, and it included several panels of diverse ADR professionals, and each panel tried to provide a different perspective, from telling us their personal journeys to discussing what attributes might be needed to become arbitrators and mediators. And it also included a panel of our past Higginbotham Fellows. And we got a lot of positive feedback from the students in this event, and some of them came from parts of the United States where they did not see diverse arbitrators and mediators. And so for them, this was really a very, very positive experience. We got very positive feedback from them. So, you know, moving forward in the COVID world, we of course are still moving forward with these diversity initiatives. Unfortunately, COVID hit, and our 2020 Higginbotham program, we could not do it in person. But we decided on the Higginbotham program to actually put it off till we can meet in person, which we hope will be in May of 2021, because I think in that program, the actual for the Higginbotham Fellows to actually meet in person and to make those connections, which is a little bit more difficult to do in a Zoom format, is really important. But we did have an event with the Higginbotham Fellows where we did do a Zoom kickoff event, and we are attempting to keep in touch with them until May of 2021. Hopefully by then we will be able to have an in-person meeting. But I also think that sort of I think that diversity efforts can continue in this post-COVID world. And I think in some ways, because of Zoom and because people don't actually have to travel to get somewhere, they don't have to expend the expenses to get somewhere, in some respects, we could possibly even reach a larger audience, because I think you now have people who could sign up for a conference, and no matter where they're located in the United States or in the world, and participate. And so I think it does give us, in some respects, a way to reach a larger audience, possibly. We have, over the past few months, started to also do this virtually by getting in front of audiences at bar associations, meetings, conferences, etc. All these events like NAMWOLF, etc., are going forward. And so what we're looking for is that opportunity to get in front of those audiences, because I think what happens with people, I think people sometimes think it's much more complicated to become an arbitrator. Of course, you have to have the qualifications that each panel might require, or any other organization might require. But I think when you actually explain to people what is needed, and how that it's not as imposing a possibility as they might have thought that it is, it encourages more people to come forward and to try to join those panels. So I think in some respects, we might actually have enlarged our audience, which is sort of a positive. But we continue to do this. And I think also it's important to encourage corporations and law firms to pick diverse arbitrators. And I think that sort of aligns with what Leslie and Paula are talking about, just what's happening within the firms, and to take that to the step of not only making sure that everything's allocated fairly, and also making sure in terms of the corporations, Michelle, Michael, making sure that when there is an arbitration, that is a consideration when choosing panelists, when choosing an arbitrator from whatever lists you're receiving from organizations. So I think that was an issue pre-COVID. I think it's an issue that continues to date, and something that, you know, we really, that is the flip side of having, we were able hopefully to increase the diversity of panels, but we also need to increase the amount of appointments.
I'm going to jump in with a question with Amanda's permission. And I think you bring up a really good point regarding, concrete steps that institutions can take to increase the pool. And it seems like you have been able to be successful with respect to the pool of arbitrators or neutrals that handle labor type disputes. But a question for some of the people making decisions when it comes to neutrals. So this would be the partners like Paula, or the companies whose disputes are going to be in front of neutrals, either mediators or arbitrators like Michelle or Mike. So a question to you guys, a two-part question. One, do you see some of these concrete steps that institutions are taking in fact increase the pool of diverse, or rather, in Mike's words, representative lists that you are getting from institutions to pick the mediators or to pick the arbitrators or what have you? In your view, is the pool in fact expanding to include a more representative subset? And when it comes to, that's part one, and part two is, what measures do you undertake, or your institutions undertake, to ensure that when a neutral is to hear one of your disputes, that in fact you are considering not only the people who are at the forefront of your mind, but rather go beyond the first or second choices and look beyond to more diverse candidates? I say that in the backdrop of noting that the USMCA, with the new NAFTA that's just going into effect, just had the United States, as well as others, list a number of neutrals that will hear the state-to-state disputes. And already there is criticism that the United States, at least, has put names that is not representative of the United States with respect to the type of neutrals that can hear these type of disputes. So it seems like, while institutions are doing what they can or trying to take measures to address this issue, I feel like it's an issue that keeps coming up over and over. So I wonder, back to concrete, what they can do.
If I could, I'd say, from a party perspective, I take off my hat in terms of doing work with institutions that we do occasionally, just purely as a party. I'd say not really. We don't see it. It's not that we don't appreciate that efforts are taken. I think the ICDR, using as it does a list process, is able to put a few more names out there, so it has opportunity for us to see more diverse slates, and we can ask for diverse slates. But the problem is not that we don't want to appoint diverse people. The problem is that we want to appoint people that we know. And it's kind of the issue, it goes back to the issue that the law firms are talking about. The work goes to the person that you feel comfortable with because you know them. And so, what institutions are not doing is giving us better information about how arbitrators we don't know, diverse or non-diverse, just in general, about arbitrators, mediators, about people that we don't know. How are they going to conduct cases? How are they, what information can we use about them that can make us comfortable appointing somebody that we don't know? It's good for diversity, but it's just good in general for expanding and making the pool a healthier pool. And it would bring diversity along with it. Because if you look at the data in terms of appointments, And I think I have some of the ICC data. The ICC is going to release its data on appointments next week. So Alex Faces told me I can use last year's. I shouldn't use this year's. So I'll respect my commitment with that. I asked him, but the ICC actually has pretty good historical data. They have Mires Philippe, who's worked there for ages and for, you know, since the 1980s has collected data on arbitration appointments. She's tracked gender data. And so you've seen enormous improvement over the years, and we're not there yet in terms of, you know, you don't even have arbitration appointments, for example, nowhere near at the level of where you have law firm gender ratios. You know, it's still I'd say with the ICC, other institutions such as the SCC, the Stockholm Chamber, I think have done better with respect to institutional appointments. But where you see it, it's still pretty unbalanced is party appointments, people like us making appointments. I mean, the data is not great. It's improving, but it's improving really, really slowly. How could you get us to make more diverse appointments? Well, I don't think you can. I think you have to come at us differently. You have to say, here's more information that would be useful for you. Now you're familiar with this person. And I'm like, okay, then I'll appoint that person. But not because they're diverse candidates, because I have more information about them. So I think that's one thing. The other, I think, is, you know, this is a moment, and we've talked about this kind of before setting up. I take a little bit at issue with, I think, some of the topic here, that this is necessarily going to be a step backwards. I think there's a lot of step forward that could take place right now. I see this is a big moment of opportunity for everybody. Because, you know, I know that law firms and even people, you know, working, you know, who wanted to start their careers, whether it's in arbitration or advance it within law firms or even in-house, you know, when you're starting families, or if you're taking care of aging parents, which tends to, not always, but tends to, I'd say, disproportionately fall to women than it does to men. You know, one of the impediments often was, you know, whether it was true or not, whether it was a real impediment or a psychological impediment for the people, the fact that you were at home with kids crying in the background, or you had caregivers running around and you had other things to do, made it really difficult for a lot of people to advance, whether it was in law firms or to advance their careers as arbitrators. Now we're in a world where, I mean, honestly, nobody thinks twice anymore at this point about working online, hearing babies crying in the background. My dog is barking half the time, and I don't, you know, it's like, seriously, I used to connect, oh, my dog's barking, you know, now it's like, oh, my dog's barking. So I kind of wonder if, you know, we're kind of coming at this with necessarily this might be a step backwards, whether this might actually be a moment where, using the technology and the way we're working together, this might be a leveling the playing field moment. But what I'm still missing, and I go back to where I started, is I still don't have enough information to feel comfortable about appointing people that I don't know. And that'll be hard. Right,
I would say that, you know, yeah, I was just going to say, you know, again, I had litigation as part of my remit for a period of time at HP, but I hadn't really been involved in or seen kind of, you know, arbitration and appointments and things of that nature. But I guess my question really to the group is, why can we be treated very similarly, meaning as a corporation, you can be intentional and say, you know, we're going to make sure that of the arbitrators that we choose, that they are of a diverse slate, and, you know, really try to be maybe a little bit more open about trying. And I understand this is a tough thing, because it's like so much is in weighing in the balance on getting the right result for your client. So it's just a question.
So here's interesting data on that, though, Michelle. And I credit Mires Philippe for finding this. Is if you look at even the gender difference in arbitrator appointments that she's collected over the years, she has access to incredible data through the ICC, and you find that, yeah, women are getting more appointments, but the value of the disputes they're getting is lower, not surprisingly, with respect to those of the standard of what men are getting. So are women really getting, you know, are they getting the big appointments? Are they getting their names out there in the world of, you know, the top names, the top big cases? And the answer is, well, in some cases they are, but not as much, right? Well, why? Well, because people don't, if you're a newcomer in the field, it's as you go up in the amount in dispute, it's increasingly difficult to make the case, well, you know, look, it's $1 billion bet the case, you know, bet the company case. You know, I'm all in favor of diversity, but $1 billion, I'd rather not have to, fire or lay off, 20,000 people. I mean, it's like, you don't want to put yourself in that situation. But if you had information where you'd say, look, we're not betting the case, we're actually appointing somebody who is highly capable, has the knowledge of the law. Procedurally, they wind up going where we like. They're not going to grant incredible amounts of discovery, like somebody going insane under American procedure. They're going to adhere more to the IBA rules of evidence with respect to materiality requirements. I mean, little things like that. You go, actually, this candidate, who also happens to be diverse, is our best pick because I have the information about that person.
Well, since I've never liked a pregnant pause and a Southerner cannot have any gap in silence in a conversation, I'm going to jump in here and say, am I seeing when I get panel lists from any organization enough diversity? No, absolutely not. Is it better than it used to be? Yes. But Mike has hit exactly on the point, is I'm doing the $1 billion cases. I'm representing my client and making the example of laying off 20, 30,000 people if this thing goes sour is what the consequences are if I make a bad choice. So information is essential. And I was sitting there listening to Mike and I thought, well, maybe because I'm always about, what about solutions? Maybe in the selection process, what we need to think about for the future is shaking it up in the organizations. Maybe we need to have the clients and the outside lawyers interview the people who meet the threshold, interview them like they would with me, and find out the facts about those individuals for the selection process. Now, I've never been offered that opportunity. It's like, here's your list. They say they don't have conflicts. Do your strikes, you're done. But maybe we need to think outside the box of methods that these people who need experience can get interviewed, and Mike can ask the questions and I can ask the questions. What's your experience in this arena? Because otherwise we don't know, and it's a giant risk to take with the unknown.
Thank you very much. So let's move on to our next topic.
I could point out, one area where you have seen a lot of progress over the last, I'd say 15, I've been an in-house counsel since 1999. One of the things I've noticed is that at least the leadership within mediation and arbitration institutions, I think that is where you've seen a lot of progress, particularly with respect to gender diversity. And I have the data, for example, from the ICC, for example. I know the AAA has done also incredible things. The ICC court is at this point now 50-50 balanced. The ICC, the Commission on Arbitration and ADR is today much more diverse than it was. Those are people who are, that's an interesting actually data point in terms of leadership, because the members of the ICC Commission are nominated by national committees. So the ICC doesn't control that. That just reflects changes of diversity and dispute resolution around the world. And what you see today is that's about 1/3 women. So, but I'm told again by Medez that 20 years ago, you could, these are like 908 people that 20 years ago you could count on 2 hands the number of women who were a part of the commission. So I think in terms of leadership, I think you've got the people now, at least with respect to gender, you're in charge. And so why not make some changes while you've got the ability to do that?
I know there's not a pause, but Paula made me think of something, and Michael, you kind of brought it home in my head. And when I practice, I was not a litigator, so this might not be a good thing to say, but I just wonder whether something like the Rooney Rule could be helpful. So it would encourage people to interview someone who was diverse. They didn't have to pick them, but they had to at least interview someone who wasn't a usual suspect. That might be helpful.
Thank you very much. I think that hopefully moves us into our next topic. Recent developments in the US have shone a spotlight on racial diversity in particular, and many have suggested that we've reached a pivotal moment in this important discussion. So Leslie and Paula, how do we best seize this important moment in the racial diversity debate to achieve gains in the legal profession?
I think Leslie would agree with me. We have the attention of the people at the highest levels of power within the institutions, and now is the time to keep the pressure on them to make the changes. That's what we do. We don't take our foot off the gas. Leslie?
Well, you can see by my white hair that I've been around the block a few times. And as a Black woman, I've been waiting for this moment my whole life. I didn't want it to be purchased with dozens and dozens of my people's blood, but there is a moment. And as a diversity person, it's a really exciting moment, but it's a really fraught moment as well. Because, I mean, there's a few reasons. That the first reason is that well-meaning people have used this moment to examine themselves. And that's fabulous, because nothing is going to change unless people examine themselves, admit where they are, take risks, are awkward with people of other races and genders, and try to build bridges. But this awkwardness has to have a midwife. And in a lot of institutions, that's your diversity and inclusion person. So all of a sudden programming about allyship and who you are and how to detect your own bias are, de rigueur. So that's part of it, and that's a wonderful moment. And then an offshoot of this moment is that people are really wanting to have their own programming or their own, looking at a law firm perspective. Well, why don't we do this? Why don't we do that? So there's a bubbling up of all these wonderful ideas that people for the first time are personally investing in diversity and inclusion. And that's wonderful. And then the third thing is there's this global reflection. They're using the inflection point of what's happening in America for diversity, and they're using it kind of like a magnifying glass in their own culture, their own people, and saying, oh, we can diagnose this in our culture. Maybe we can do these things better. Maybe we can learn from what's happening in the US. So you have those three forces kind of all hitting like that. And then you have me as a diversity professional thinking, I love all of this energy. And I hope this moment lasts a very, very long time. But there are things that have been underway, and there are some things that are better than others in my experience in moving us along on the diversity spectrum that I want my firm to do. But I also have to give credence, give voice to all these other things. So now I have to twine all these other things with things that I know that will work, like making sure that the feedback system, that people know how to give feedback across difference, that diverse people know how to accept feedback, that people with lesser power don't have to work harder to get feedback, as an example. Perhaps having goals for progression in diversity, that's an example. So it's a very interesting moment, and I just hope people of goodwill can work together to keep this moment alive and to do things that are both that you feel passionate about and that are self-reflective, but yet move the diversity agenda along.
Thank you very much. The pandemic has raised a great many challenges, but it's also provided opportunities across the ADR spectrum. And in many ways, it has perhaps brought the global international dispute resolution community a little bit closer together. So I'm keen to talk now about some of the opportunities that you have all seen that have arisen for individuals, for law firms, for institutions and users. So how has COVID helped to level the playing field for diverse practitioners and aspiring practitioners around the world?
Well, I'll jump in. Kind of to Anne's point earlier when she was referring to the fact that, the technological capabilities of Zoom has really enabled us to reach into folks that might not have the ability economically or otherwise to participate in certain things. Now, obviously the technology is one threshold that needs to be overcome to ensure that people have access to the technology. But I see the fact that you know, we have overnight, and we're very fortunate in the legal profession to be able to utilize this technology and to continue to work fairly effectively. But it's a really great opportunity to be able to reach into others more broadly, to get more closely connected with them, whether they're people with disabilities, people in different geographic locations that you might not have had access to. Certainly a company the size of HP, we have about 55,000 people, and we had to overnight, try to make sure that our technology worked. And it's mind-boggling that it really did with very little hiccups along the way. And it's also taught me, as I took over a new group in November of this year, my team spans 38 countries. And I had hoped that I would get an opportunity to meet different people in different locations where I had sort of, more groups together, but I certainly didn't think I would make it to 38 countries. What the technology has enabled me to do is to get to know every member of my team so much better, because I can see them. We have small group, I call them Ask Me Anything meetings, regularly, where I am put on the hot seat and I get every question imaginable, but it's fantastic. And it's also enabled me to get to know people that I otherwise would not have had the opportunity to get to know so well. And I think that can be leveraged in a way to really propel diversity forward, and give access to those in whether disability or geographic location that we might not otherwise have seen as a potential candidate.
I'm going to say from a law firm perspective, I don't think COVID has leveled the field for diverse and female attorneys. I think that is requiring programs we talked about before, and Leslie's comment about constant oversight of workflow and workload. And I think what you would find is the biases, implicit or intentional, that are in the work setting almost got amplified by going remote in terms of who you're going to work with. And that the diversity professionals now in this world have to maintain constant oversight that the women and diverse attorneys are getting their fair share of the work. I think actually it's made it more difficult in the law firm arena. And if we didn't have oversight going on that, more people would fall through the cracks.
I want to agree with what Paula said and just say, I'm hoping that one of the outcomes of this COVID and racial reckoning that we're having, I'm hoping that more companies and firms invest more in diversity and inclusion. You know, I'm hoping that these forces have shown that you need to do it. People have had time to reflect, and that part of so much more of your brand is based on how you look to the world, and diversity is such a big piece of that. So I'm hoping this moves diversity up on the priorities for spending.
And I just have to say one more thing on the international perspective. The low-hanging fruit from the international perspective is women. Work in your organizations internationally and in your law firms with your women, providing them opportunities, training for advancement. So I wanted to make sure we got that in there, because my last trip before shutdown was to Paris for a meeting with the women from our international offices for 2 intensive days of training, career training, clients coming in and speaking. And we need to be doing that. So there's the low-hanging fruit from the international perspective is please focus on your women.
Any more perspectives? Can anybody give an example of any positives at all?
look, I don't purport to have any answers to this. I think that this is a moment where you need to be careful to have pretty words and to make commitments and say we're all going to do better. I think this is a moment where people, which is why I'm reluctant to do that. I'm reluctant to say, let's make a pledge, let's do this, let's do 30% better or whatever. I just feel like it's time. The time's gone. I mean, you got to turn to deeds now. You got to let facts speak for themselves. And if we don't see that, then we're not there. In 2004, Professor Ben Davis wrote this, I think, a really important article that I hope, Amanda, you may have read, which is, I think it's called The Color Line in International Commercial Arbitration. Ben's a professor in Ohio, at the University of Toledo, and he worked for years. I think he was the Deputy Secretary General of the ICC. And he just noticed that there's nobody of African-American descent, or nobody, there's just very, very few of African-American descent in international arbitration. And he updated that recently. Well, he didn't update it because there's nothing to update. There's been no change since 2004, but he published an article recently that looks at some studies by Catherine Simpson at international arbitration practitioners. And she found something like, 1.5% of those who are, of the 3,000 some practicing at the major law firms in America are of African descent. So if you have a 1.5% that are practicing at the law firm, it's going to be kind of hard, to expand the pool of those in that group in international arbitration. So, I mean, I think it's like we all kind of have a stake in this, but I mean, and I would say everybody, if you're an African-American practitioner, you need to do, now's the time to push. If you're a law firm hiring, if you're companies, I think we all kind of need to doing our part. But if we just stick around with like, this is a great ideal to have, let's go after these lofty notions, I think we're just going to have more frustration.
Well, I was going to add on to what you said, Mike, because I know, from a company perspective, what we do and what has been really kind of a cornerstone of who we are is diversity and inclusiveness. And it starts from our board of directors, and it starts from our leadership team. And our leadership team is held accountable by our board on diversity, and they're measured by it and they are compensated by it. And so, that is a really critical piece. So you can have a lot of lofty ideas, but if you're really going to be held accountable, you really have to use both the carrot and the stick approach. Regrettably, maybe we'll get to a point in time in the future where that's not necessary. But when we all met before, one of the things that I have been really very impressed by is we have probably one of the most diverse board of directors in technology out there. Women and men that are of African-American descent, people from a variety of different cultures and different backgrounds that really bring richness to our board discussion and discussions with our executive team. Could we do better in our company? We can always do better. But going back to your point of, Leslie's point that we're at a pivotal point, and how do we keep that momentum going? We keep the momentum going by really holding people accountable and holding each other accountable. So not only setting the goals or making the pledges, but holding the people accountable for delivering against them in a very meaningful way.
Thank you very much. Just to highlight one slightly positive program that's come out of the lockdown situation. There's been an initiative that's called Mute Off Thursdays that brings together women from all over the world for 30 minutes every Thursday to educate each other and share. So that's a positive development to try and put a very, very tiny silver lining on a very difficult topic in a very difficult situation. So our goal today was to try and produce a concrete checklist of steps that can be taken across the dispute resolution user spectrum to protect some of the diversity gains that we've experienced in the past and ensure that diversity, at the very least, doesn't take 2 steps back. So we've discussed a number of different steps today. And so what I want to do at this moment is turn the floor over to Imad to talk a little bit about some of the steps that he's been recording, and then we can talk perhaps about any further practical steps that anybody can come up with. If anyone's been saving their very best idea for the last minute, then hopefully we can add that to our checklist at this stage.
Thanks, Amanda. First of all, thank you to everyone for a lively discussion. I agree with Mike that, I think I certainly do not have all the answers, and I don't know that anyone necessarily has the answer to the challenges that we continue to face. At the same time, though, at least I'll just add this before I go into what I have recorded. Having discussions like this reminds me that this is a topic I really care about, and that I share that care with people who are attending as panelists today, as well as those who are listening to us, and many others who are putting together similar type of programs. So just even talking about this, I think, helps us think about it on a somewhat regular basis so that we can actually effectuate steps that we were talking about today. So with that, I will endeavor to capture what the group had talked about in terms of concrete steps that one might take. And there are certain themes that, at least for me, arose during the discussion. It seems like when it comes to law firms, but any business alike, it's rather important, concrete step number one, to monitor the allocation of the work that goes to those from a well-represented background. Now, those could be diverse attorneys, women, people from different parts of the world, essentially people who don't just act, look, speak like yourselves. A way to make sure that that doesn't blockade the people that we are able to recruit into our organizations. So an enforceable way to monitor and allocate that work is step number one. On a more senior level, it sounds like law firms, companies, and other places alike can also ensure that the people from diverse and representative backgrounds advance into higher positions. So it's not just about recruiting and training them at a younger stage, but rather making sure that they advance well into their respective careers. And one of the suggestions put forth was that to ensure that these people should have sponsors or sponsors that are in positions of power, that that's what it requires to make sure that the advancement actually does occur. So that's number two. Number three is really about what corporations or in-house counsel or companies could be doing. Essentially those who pay us to do what we do, because they have quite the carrot and or stick to be able to enforce diversity measures. But what those companies and clients can do is not only establish the rules or the lofty ideas, as it were, but also enforce them in a certain way. So I like the idea, well, I'm an associate at this point, but I like the idea of this 10% withholding if you don't measure up to the HP standards. But that's one way in which to make sure that people who are your vendors, including law firms, are actually enforcing your vision and your policies regarding how you want to run your business. That's something for corporations and clients to do. The next two, five, really have to do with, in particular, litigation, disputes, international disputes, as it were, things that Anne had been talking about. One thing that must be done is to increase the pool of diverse neutrals, and about some of the steps that have already been taken and in certain respects have actually been fruitful. But monitoring and increasing the pool is important through concrete steps such as trainings and other things to expose people from diverse backgrounds and representative backgrounds to become part of the neutral pool such that those can be picked. And then it leads into the next and fifth concrete measure, which is perhaps a new idea of sharing, creating more information so that users of international disputes or domestic disputes, or what have you, can feel comfortable to select people from diverse and representative backgrounds. I'll note that at least in international arbitration, it's not just about having a diverse candidate, but it's also about having someone representing the globe in which these disputes take place. It's about making sure that those lists that we get are representative. And if we are to feel comfortable selecting someone who isn't necessarily the first, second, or third person that comes to mind, what that might require is more information. So perhaps an idea for institutions might be, how do we allow for access to such information to facilitate lawyers and in-house counsel to select someone who isn't necessarily the first, second, or third choice. So with that, I hope that I have somewhat accurately, hopefully, collected the thoughts of this group in terms of concrete actions. And it's not just so that we have concrete actions, but ones that we can take back to our organizations, friends, families, discuss and put into play, not just for the speakers and panelists today, to whom we are very thankful, but also for those of you who were able to join us. Hopefully these are things that you can implement.
Absolutely. Thank you very much, Imad, for the very cogent summary of the concrete measures that we can hopefully focus on in the future. Thank you very much to our fantastic panel for sharing their perspectives on this important topic. I have no doubt that we could have kept talking about it for another half an hour or so. There's so many things to say, there's so much to discuss, and it's so important that we do have this dialogue. So maybe we'll have to have a sequel at some point in the future. We're very grateful to ICDR Y&I for hosting this event and to Arbitral Women for supporting it. And thank you very much to Rafa and Louis for all their support putting together today's program behind the scenes. And lastly, thank you to everybody who is listening to this program for joining us today and for asking questions.
Thank you very much for having us.